What to mention?
Yes.
My lord, I beg to mention item number 14, my lord. My lord, in this case, my lord, respondent file an appeal in opposition. My lord, petitioner also file, my lord, rejoin the application. My lord, matter, I mean, to pray for my lord, the call for the, my lord, rejoin the application.
May I please, your lordship? I beg to mention for listing, lordship.
After Bihu, any date?
Lordship, still it is pending in motion, lordship. Still it is not.
Motion. When do you want it?
Friday, lordship.
My lord, may I please, your lordship. My lord, I beg to mention, my lord, one for listing, my lord.
Hmm.
This is old pending case, my lord.
Put a date after Bihu.
My lord. Obliged.
Please, lordship. I have also paper for listing, my lord. Admission matter.
After Bihu, put a date.
May I please, lordship? I beg to mention for listing of WBC on Friday.
You heard it. After Bihu, put any date. Hmm.
My lord, the long the content matter is pending, my lord.
After next Bihu. What is the urgency in content? Put it after Bihu. Yes.
But there is one matter, item number 22, my lord.
Yes.
This is for hearing.
Hmm.
There are Mr. Ken Chaudhary also for some of the petitioner.
Yes.
I have been engaged, my lord, yesterday in this case.
Hmm.
So, my lord, if it is not inconvenient, my lord, can it be placed after Bihu vacation? It's a hearing ultimately, my lord.
Item 22.
Yes, there are other councillors, Ken Chaudhary also there. We have to inform also.
Yeah, the consent is obtained.
My lord, the government is there, my lord. Ken Chaudhary is with some of the writ petition. I am also representing for the writ petition. We'll inform Mr. Chaudhary, my lord.
If on consensus, this court doesn't have any
Yes,
problem.
we'll inform,
Mr. D. Das Lanet, Senior Counsel appearing for some of the, you are for the respondents here.
No, we are for the petition.
Petitioner in WPC number
3900.
3900/2017 submits that he has been recently engaged to argue this matter and therefore hearing of these writ petitions be adjourned till the ensuing Bihu holidays. Full stop. Full stop. The prayer is not opposed by the other counsel appearing in this case. As such, these matters stand adjourned till 27th of April.
Chaudhary Junior is also there.
Yes, 27th of April.
A little not.
27th, registry to list these matters accordingly. Yes.
Supplementary list for withdrawal item 27.
Lord, I have been engaged in this case. There was a writ petition which was filed. Subsequently, there was an order that has been passed by the government whereby my writ petition was rejected. That was not a part of the earlier writ petition where writ petition was pending. So it's a different cause of action. So I told my learned friend that we should withdraw immediately because different cause of action. I have to challenge that order. That writ petition rejected. So Lordship will give a permission. My lord, we'll withdraw it with the liberty to file a fresh one.
Mr. D. Das Lanet, Senior Counsel, assisted by Mr. D. Mahanta, submits that due to the subsequent developments taking place concerning the issue involved in this proceeding, the petitioner will be granted leave to withdraw this writ petition with liberty to file afresh. The prayer is not opposed by Ms. S. Borua, Learned Government Advocate Assam, and Mr. N. Upadhyay, Learned Standing Council, Irrigation Department. In view of the above, this writ petition stands disposed of with liberty as paid for.
All right.
Okay, list for motion item 1.
It was for instruction. I had seek for a disposal in light of the annexed High Court order. And Lordship had asked for instruction from the other side.
My lord, actually, what page 83, that order was passed in the motion stage. Because they are submitting an application representation that was pending. That's why I agreed that the pending representation may be disposed of. That is the order. Now, in this case, Malad, they have not submitted a representation, I think, Malad. PSO, regarding PSO, Malad. Regarding PSO, 145 post was advertised, Lordship, award of the Malad. That has been filled up by selection. I think they may not participate or may
No, we
not
have
be
not
selected.
participated.
If they participate, they may not be selected. That's why they have come. But this order is Malad.
All right, let me see, let me understand what is the case, what is your case, Mr.?
Lordship, this is, I beg to differ from the other side.
No, you present your case.
Okay, Lordship, our case is that these people were appointed between 1996 to 2008. Some in 1996, 4 of them were in 1996, some in 99, and subsequently different dates, different years. And since then, they had been serving initially as Home Guard, and thereafter from 2012 to 2017, they served as SPO. Now, Lordship, that is a separate case. That one exam was conducted, and ultimately the problem with us is that our age is already over for sitting in those exams.
No, you were appointed means where is your appointment order?
Lordship, Annexure A, if Lordship sees, these are our training certificates.
That's all right, but where is the order of appointment?
Actually, Lordship, some kind of common orders were made. It is not annexed here. So actually, it is not separate orders for each of them. There is some common command or certificates or command orders were given. So in Home Guards, actually, that kind of order is given, and these things keep on different appointments orders are given every 6 months. So in this way, we were retained for about 15 to 17 years. For 6 months, in 6 months.
What is the salary you used to get?
Salary, Lordship, now Home Guard salary has been increased to 23,000. Before that, it was 8,000. And before that, perhaps even less. I don't know, in 1996, maybe few hundred. I'm not sure about that. So we are here because our grievance is that at this stage, even if some exam is conducted to take us, we can neither, even if we compete, we cannot compete with the fresh candidates. Therefore, our only representation is there. And we have come not as a separate representation. This representation was through our association. Lordship had already seen the association. So therefore, only consideration is whether we can be, put Lordship somewhere in some capacity.
No, that kind of things don't happen in judiciary. In judicial process, we see what is the nature of right the petitioners have. What is the relief that is being sought? And is that permissible under the law?
Now, Lordship,
that is what you will have to make out a case.
Lordship, one thing, actually, the other petitioners in the other case, in which I have annexed, now, although the order was to be passed within 2 months, ultimately 2 months has passed, definitely that is there. But as per our instruction, they may be in a better position to tell that things are moving in a positive direction to settle some of them. So that is why with that hope, these people have come, that if some order is there, they may, at least some of them may be.
Now, how they will be settled? You tell me, then I'll pass that order. How?
Now, what the government is considering now.
No, so I do not have such type of instruction. Government has already advertised, post has been declared, selected candidate already been appointed.
If you would have come with a grievance that give us some concession for the process, then it's one thing. The court doesn't know what were the terms on which you were appointed. Your appointments could have been very illegal. So maybe nobody questioning.
Lordship, they are not challenging our appointment. And
that's not the question. Question is, you want a protection of your appointment. Is it not?
No, they are.
No, listen, please, let me. You want that your clients should continue in service.
Yes.
That is called protection of appointment. Yes. But if you can't say on what process you were appointed, how can that protection be granted? Just because you were there, somebody might have, some person might have done it in an arbitrary and pick and choose manner. Why should we protect that? Tomorrow, if another 2 lakh people come with similar prayer, can the court entertain that? You have to tell us what is the system through which you came in. The system is illegal, you have to go.
So, Lordship,
can't be helped.
Lordship, actually, the system of keeping these home guards, these are ultimately very, we can say it's an arbitrary
Mr.
system.
Chaudhary, two options. I can close it today, or you can get some more time to develop your argument. This kind of blind orders, consider representation, you will not get from this court. I'm in court number 5.
The lordship will.
Because
give
these
some-
are nothing but breeding ground of contempt cases. You have to show me what is your right and how the government can do it. We'll direct them, and once this court passes an order, it has to be complied with.
Then lordship will give me some time because this court at an earlier point of time, so far as tea plantation security forces were concerned, had passed an order of mandamus, and ultimately they were taken into AISF, saying that so much arbitrarily this service conditions were made that every 6 months and a person continues for 20 years and then is left out. He has no right.
Then you make or develop that case.
Then lordship will give me some time in that way, that manner.
I'll issue notice then. You
Yes.
come up.
Sorry.
But you have not taken part in the recruitment process.
No, we have not taken part. Because
So
we
in the
ultimately cannot
context of the
complain.
recruitment process, you can't seek any.
No, that we are not seeking here.
Then we'll issue notice, but you have to make out a case.
Yes, lordship, I will.
That case has to be, you have to say that, show that you have a legally enforceable right.
Yeah.
Otherwise, maybe you can still show something. Maybe you can still invoke Article 14, 16, etc. But you have not done it in this case.
Yes, lordship, actually today I was thinking of this
No,
representation.
in
itself.
today, no, while drafting the petition also. Mr. Chaudhary, the problem is some judges read the brief. That's the problem. You may not take care to write your petition properly, but we do take care to read your petition. You have not projected any case like that. Your only case is we have been working since so-and-so. There is a recruitment process. So direct them to absolve us. That's your case?
Yes.
How can that be done? Under which legal
So,
principle it
lordship,
can be
the
done?
recruitment process.
Just because some other case, some other court has passed some order, we don't know what is the facts of
Yeah,
that case.
lordship, I will look into.
We'll issue notice then.
All-
Heard Mr. M.K. Chaudhary, Learned Counsel for the petitioner. Also heard Mr. T.C. Chotia Laner, Additional Senior Government Advocate Assam, appearing for the state, who prays for some more time to obtain instruction in the matter. First, the petitioners were apparently engaged as home guards some 15, 20 years back.
Yes.
Due to the new recruitment process of home guards / PSOs initiated by the authorities on the basis of an advertisement notice, the petitioners apprehend that.
Lordship, some clarification has to be here perhaps. Lordship, actually, after lots of dharna by this organization, actually 1200 home guards were left out. And they had not new process for home guard selection. Home guard selection is still in the old process. Actually, this was made for AISF constable selection. These are
Alright,
sanctioned posts, 145 posts. So home guard selection is still by the old process, 6 months basis.
So your clients have become unemployed.
Unemployed now at this point.
20 years back, but after rendering long years of service, the petitioners have been rendered unemployed. As such, they have approached this court by filing this writ petition seeking a writ of mandamus, directing the respondents to regularize them in the post of AISF constable by raising a new battalion. That's correct?
Yes.
By raising a new battalion.
Yes.
How can the writ court give this kind of orders?
Lordship, no,
Raise a new battalion,
Lordship,
take them in.
No, this was there, Lordship, in the ATSF case. 2 battalions of AISF were raised from this tea plantation security forces. So, Lordship, I will
What is
look
the
at
principle? I'm asking you one question again and again and again. What is the principle?
the principle,
The
Lordship.
judges are
Yes.
expected to
Yes, yes,
dispense justice in
Yes.
accordance with law.
yes.
Not like
Yes, yes. No, Lordship, actually, in 2 lines, actually, briefly, the principle in that case was that state being a model employer cannot use the service for somebody for 15, 20 years without any guarantee of tenure or without any guarantee of service. And in that manner, I mean, they cannot. So that was the basic the reason taken in that judgment.
all right, that judgment we'll see when the time comes. Notice has been issued here? No.
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 Issue notice returnable in 4 weeks. Since Mr. Chutia has appeared and accepted notice on behalf of all the respondents.
All the respondents.
All the respondents. No formal notice is required to send in this case. Extra copies of the petition be furnished to the learned department counsel, so as to enable them to obtain instruction in the matter. You develop a case,
Yes.
do some hard work.
Yes.
Don't just come to the court showing another order in another case.
Lordship.
What is your case? Convince the court, you get an order.
Objection.
Item 2 and 3.
This is MH Chaudhary, huh? No. What is, your name is MK or MH? MK Chaudhary. All right. Yes.
May please, your lordship. But before placing the law laid down by the Honorable Apex Court, I'll just in a very quick manner would like to place the factual backgrounds of the case. Not issue involved in the present writ petition is with regard to unauthorized absence, and the period is in question. That is 27/6/2016 to 26/8/2016. 27/6/2016 to 26/8/2016.
Yes.
He initially applied for CL and headquarter leave from 23/6/2016 to 24/6/2016. Of which 25/6/2016 and 26/6/2016 were government holidays.
Which were government holidays?
25 and 26. 25th June 2016 and 26th June 2016. He left for Mumbai by flight on 24/6/2016. Reached Mumbai on 25/6/2016. Both the writ petitioners, my lord, got treatment under Dr. Vinod S. Shirodkar on 27/6/2016. As per the pleaded case, my lord,
both the writ petitioners means how many petitioners?
There are two petitions, my lord. Ananta Prasad and the next one, my lord.
Next one is by whom?
By the Anjuma Begum, with whom he got married in Mumbai, my lord. They fled away from here. And
Anjuma Begum is also in service.
Yes, my lord. She is a copist. She was a copist, my lord. So both of them fled away from Goa, my lord, to Mumbai and got married there. There were FIRs filed by brother of Anjuma Begum regarding, my lord, all those things. I'll just place. So both treated by Dr. Vinod S. Shirodkar, and as per pleaded case, Ananta Prasad was suffering from respiratory problem, and Anjuma Begum was suffering from skin disease. So both of them were treated by this doctor. My lord, the medical certificate, your lordship will find annexure 1, dated 23/7/2016.
Page number
23, my lord. The lordship will find Sri Soham. This is to certify. This is a Surya clinic. Doctor's name is there. Date is 23/7/2016. This is to certify that Sri so and so suffering from acute bronchitis and breathlessness, indigestion, gastritis.
But you say he reached Mumbai on 24/6.
Yes, my lord.
And this certificate is of
Left for Mumbai on 24/6, reached Mumbai on 25/6.
But the certificate is of 23rd.
Yes, my lord. 23rd, 23/7.
23/7.
7. and this certificate says that he was under treatment of this particular doctor on with effect on from 27/6/2016. Certificate was issued on 23/7 and treatment was done on 27/6/2016. Then, my lord, he sent an email along with an application for earned leave. Your lordship will find page 2, annexure 2, page 24. This is dated 27/6/2016. Prayer for earned leave with effect from 27/6/2016 to 20 August 2016, along with headquarterly permission from morning so and so so and so. May I inform your honor that I shall go to Delhi in the morning of so and so on account of my medical checkup and treatment, as I have been suffering from various ailments, and few months back I was undergone surgical operation, and recently I am facing physical problem for which earned leave with effect from so and so, along with headquarterly permission from the morning of so and so to so and so is prayed for. Therefore, I request kindly earned leave, request you kindly me earned leave along with headquarterly permission for the period as stated above. This is dated 27/6/2016, and he said he shall have to go to Delhi. This was sent via email that your lordship will find page 25. Then the brother of the Anjuma Begum, he lodged an FIR, my lord. That your lordship will find page 26. To the officer in charge, Dhubri Police Station, with due respect, I have the honor to state that my younger sister Anjuma Begum is an employee copyist of MSAD Dhubri. That on 24/6/2016, she attended her office at 10 a.m. But till evening, she did not arrive at our house on the very day. Later on, we, the family members, searched her in different places but could not found. On so and so at 4:45 p.m., the accused number 1, who is also an employee of the same office, rang over to my mobile phone by number that my sister Anjuma Begum is in their custody. I tried to talk with my sister, but the accused number 1 and 2 named below did not allow her to communicate with me, and her mobile cell so and so so and so so and so switched off. Again on so and so at 8:30 p.m., the accused number 1 and 2 called me over phone and demanded so and so. Otherwise, her dead body will send to my house. I reasonably doubt that the accused persons kidnapped her for the purpose of illegal gain. This was the FIR filed by the brother. Now your lordship will kindly turn to page 31. This is the order by which his leave was rejected. This is dated 29th June 2016. Lordship, sir.
Yes.
Notice order dated so and so. You are hereby informed that you have been unauthorizedly absent from duty in this office from 27/6/2016 till date. You are also unauthorizedly absent from station headquarters. The undersigned has received your application seeking earned leave with effect from 27/6/2016 to 28/2016 through email, which was sent on 28/6/2016 at about 10 a.m. Your application for earned leave is not supported by any medical documents. Further, a criminal case being Dhubri PS case number so and so has been registered against you, which is under investigation based on an FIR lodged by brother of Ms. so and so copies. The undersigned is not satisfied with the grounds, reasons, and justifications for earned leave as sought for by you, and accordingly the same stands rejected at this stage. Accordingly, you are hereby directed to assume your duties and to attend office forthwith, as your absence from office duty as well as from the station headquarters Dhubri on and from 27/6/2016 is unauthorized. This was the order by which his prayer for earned leave was rejected. Then, my lord, show cause notice that your lordship will find annexure 5.
Okay, so he did not report back for duty.
No.
When did he report back for duty?
He ultimately reported back for duty. He reported back on 17/7/2017. Because he was placed on the
2017.
yes, my lord. There is a letter written by him to the presiding officer, page 95, wherein after the suspension order was vacated, he prayed that
So
he may be
you
allowed.
proceed as per your.
Yes, my lord. Then, my lord, your lordship will find the show cause notice, page 33, as to why a disciplinary proceeding shall not be initiated against him. Page 33, annexure 5. He again through email submitted a reply. Submitted an application praying for earned leave that you also will find page 35. Prayer for granting earned leave as prayed for, write my application dated so and so. Second paragraph, my lord. In this regard, I informed your honor that I was on casual leave from so and so to so and so, along with headquarter leave permission, but due to my medical urgency, I left outside the headquarter for better medical checkup and treatment, for which I could not produce the medical documents before your honor. However, after completion of medical checkup and treatment, I will submit my medical certificate before your honor. And in anticipation of my medical certificate, your honor may kindly be allow me the earned leave along with headquarter leave permission for the period as prayed for earlier. Moreover, FIR lodged against me for abduction of so and so copies is totally false. It is nothing but to harass me and spoil my reputation. In this regard, I'll produce all my necessary papers after completion of my treatment regarding false ejahar lodged against me, and which will prove in the court of law in due course. Now, the disciplinary authority, my lord, he tried to serve the show cause notice to the petitioner concerned, but since he was out of station at Mumbai and his family members also did not accept the show cause, so that's how it has to be circulated through paper publication. That you'll also will find page 39, annexure 7. And the original, my lord, will find page 42.
Then what happened?
Then on 21 July 2016, sorry, it's not the same thing. Then page 46 is the suspension order, my lord. He was placed under suspension. Then he again submitted an application.
Yes.
Then he again submitted an application, page 48. Prayer for extension of my earned leave with effect from 3/9/2016 to 9/9/2016. You know, his earned leave was not granted and he prayed for extension of earned leave. With due respect, I have the honor to state that I have been detected by dermatologist that I have a chicken pox virus, for I need bed rest for a week. In this connection, extension of earned leave with effect from so and so to so and so in prayer for in continuation of my earned leave application before your honor. Therefore, I request you kindly arrange for extension of earned leave for the period thus applies. It needs to be mentioned that earned leave application form and medical documents I will produce before your honor. I will produce. This was also sent through an email of 7 September, that you will also will find page 50.
So what is the order passed here?
The order, the disciplinary authority imposed a minor penalty, withholding of increment, that you will also will find page 21.
Mr. Sharma, are you serious
Page
about?
98.
See, your client left with that lady to get married, and that was the whole purpose. We may also consider directing them to enhance the punishment. That possibility is there.
The FIR lodged against him has been paused by the Honorable High Court.
No, FIR is fine. FIR
Page
is fine.
85, my lord. And
FIR is
he was, your lordship kindly see the my page 10, para 3.
All right, you get
He was
ready.
first-
Yes,
first, my lord. he
we'll
was
hear you. Let him finish. We'll hear you.
my lord.
Let him finish, then you respond to this.
Then charge sheet was issued page 61, my lord.
Hmm.
You also will find the charge sheet. I'll just read the charges, my lord. Page 61, down below, my lord, charge that you being suggested our office of MACT Dhubri were found unauthorizedly absent in your duty, as well as from headquarters from 27/6/2016 till your date of suspension on 26/8/2016. Even though you received the order notice dated 29/6/2016 rejecting your prayer application for earned leave. For your aforesaid act omission conduct, you are charged with negligence of duty, dereliction of duty, breach of discipline in your official work, and duty which amounts to misconduct. Thereafter, he was directed to file written statement. And I'll just like to read the statement of allegation, page 63, my lord. Second parameter, whereas the office of undersigned received through email on 28/6/2016 your application dated 27/6/2016 praying for earned leave with effect from 27/6/2016 to 28/2016 along with headquarter leave permission on medical ground. Whereas in your application dated so and so, you had stated that you would go to Delhi for medical checkup and treatment. And whereas in the afternoon of 27/6/2016, a team of police personnel from Dhubri police station came to the office of MACT Dhubri, and in connection with Dhubri police station case number so and so under section so and so IPC, examine Sri so and so head assistant, Sri so and so LDA and Sri so and so LDA and Sri so and so process server in connection with aforesaid case, which was based upon an FIR lodged by Sri so and so, who is the brother of so and so, office of MACT Dhubri. Whereas in the aforesaid FIR, the information being the brother of the so and so alleged that you have abducted his sister, Sri so and so. Whereas in office, you had received an application dated 27/6/2016 through email on 28/6/2016 from so and so, praying for commuted leave with effect from 27/6/2016 to 26/8/2016 on medical ground along with headquarter leave permission. Anjuma Begum prayed for commuted leave, my lord. The petitioner here, he prayed for earned leave. Whereas you holding the responsible post of citizenship in the office of MACT did not submit or furnish any prior intimation or information for your earned leave, that too for a very long period as aforesaid. And whereas after duly considering your application for earned leave in the background of the aforesaid facts, the same was rejected by notice and order dated 29/6/2016, which was sent to you by email and which was received by you. The said notice order dated so and so was also simultaneously sent to your residential address by process server as well as registered post, but your family members refused to receive the same. And whereas as you were unauthorizedly absent from duty as well as from headquarters, that is from Dhubri, from 27/6/2016, a show cause notice dated so and so was sent to your residential address both by process server as well as by registered post. Same was refused to be received by your family members. Whereas as you were absent from headquarters and your residence without any authority or permission, a letter dated 19/7/2016 was sent to the address of District Information and Public Relation Officer Dhubri for publication in the aforesaid show cause notice in 2 newspapers. And whereas the aforesaid show cause notice was published in English Daily, the Assam Tribune, as well as Assam, in an Assamese daily, the Asomia Khobor, both on 17/8/2016. And whereas, though the aforesaid show cause notice, you were directed to reply within 7 days, no communication was received by this office against the two aforesaid show cause notice. And whereas you transmitted one letter dated so-and-so by email, which reflected that you received the order and notice dated 29/6/2016, rejecting your prayer for earned leave. Whereas for your unauthorized absence from 27/6/2016 till 26/8/2016 from duty as well as from headquarters in view of rejection of your application for earned leave, a departmental proceeding was being contemplated to be initiated against you for your aforesaid misconduct, and pending initiation of departmental proceeding, you were placed under suspension by order dated 26/8/2016. And whereas the aforesaid order of suspension was sent by process server as well as the registered post to residential address, but your family members refused to receive the same. And whereas on 30/9/2016, you along with so-and-so appear before Office of MACT Dhubri as well as the undersigned and stated that you had married each other in the state of Maharashtra. On 30/9/2016, both of them appeared before the MACT member MACT and they said they got married. Whereas on 30/9/2016 itself, you had submitted one letter praying for withdrawal of suspension order, regularization of earned leave, as well as allowing you to join your duties. Whereas you had annexed a copy of statement given by Sri so-and-so, MS so-and-so, recorded before learned Magistrate Dhubri so-and-so. Whereas the aforesaid statement of so-and-so, which you had submitted before the undersigned, revealed that on 24/6/2016, you along with so-and-so had left Dhubri by bus for Bagdogra, West Bengal, and thereafter taken a flight to Mumbai, Maharashtra. The said statement of so-and-so also revealed that after staying in Bombay for 1 month, you had married each other under the provision of Special Marriage Act on 2/9/2016 in the district of Thane, Maharashtra. And whereas your aforesaid letter dated 30/9/2016 was rejected by the undersigned, while letter dated 5/10/2016. Whereas your aforesaid conduct of being absent from duty as well as from headquarters with effect from 27/6/2016 till the date of your suspension on 26/8/2016 constitute a misconduct, coupled with the fact that your application for earned leave was rejected on 29/6/2016, which was received by you. And whereas in the totality of facts and circumstances and the statement of allegations duly supported by the aforesaid document, it prima facie reveals that you had absented from duty as well as from headquarters without any reasonable lawful cause or excuse, and also neglected to perform duties and thereby committed dereliction of duties, which amounts to misconduct. Whereas you, being the solicitor of MACT Dhubri, by being unauthorizedly absent from duty as well as headquarters, caused gross negligence and failed to perform your duties, thereby causing difficulties in smooth and efficient functioning of various official work, apart from causing breach of discipline. Lordship will, after reading these 3 pages, Lordship will appreciate there was the only idea to go to Mumbai was to get married, my lord. These are medical documents, Dr. Shirotka, skin disease. These are absolutely afterthought. Lord, they could have said before the member MACT that we went there for where is the requirement of manufacturing all these things, my lord? So ultimately, my lord, the disciplinary authority that Lordship will find page 21, pass the order. Sorry, my lord, Annexure 21, page 98. This is the order path. Minor penalty was imposed.
To both of them same penalty.
Same penalty. Only difference is that here the petitioner prayed for earned leave. In case of Anjuma Begum, she prayed for committed leave. Now that period of earned leave was, my lord, adjust the unauthorized leave, period of unauthorized absence was adjusted as earned leave in case of the present petitioner, and as committed leave in case of Anjuma Begum. That your lordship will find page 98, Annexure 21, last paragraph. Sri so-and-so, solicitor of Office of Member MACT is hereby reinstated to his service, deciding to withhold 2 increments to come into effect from the date of the order. his suspension period shall be treated on duty and allowances of suspension period be regulated under FR 54B. The period of unauthorized leave from so-and-so to so-and-so is to be adjusted to the prayer for earned leave made earlier. So on the last occasion, my lord, a question was raised by the petitioner that since you have adjusted the period of absence as earned leave, so where is the question of, my lord, departmental proceeding and where is the question of misconduct? My lord, your lordship wanted to have some judgment in this regard. My lord, I have brought sorry, sir. First one, my lord, will kindly take up 2003 SCC 464. That is Mansingh versus Union of India. Lordship will kindly take para 3, my lord.
Yes.
Para 3. In the writ petition filed against the order of the tribunal in the High Court, the only ground urged was that the present case is covered by the decision of this court in state of Punjab versus Bakshi Singh, wherein this court held that the period of absence having been regularized as leave without pay would automatically set at naught the order of dismissal. It was also contended that the decision of this court in the state of MP versus Harihar Gopal is deemed to have been overruled. The High Court carefully examined this contention and took the view that the decision in Harihar Gopal case is by a larger bench and this decision had not been brought to the notice of this court in Bakshi Singh's case. And the view taken by the tribunal being in conformity with the view expressed by this court in Harihar Gopal case, upheld the order of tribunal and dismissed the writ petition. When this appeal came for consideration before this court, a bench of 2 learned judges referred this matter to a bench of 3 judges in view of apparent conflict between the decision of this court in Harihar Gopal and Bakshi Singh. It is thus this matter is set down for hearing before us. In Harihar Gopal case, this court noticed that the delinquent officer, in failing to report for duty and remain absent without obtaining leave, had acted in a manner irresponsibly and unjustifiedly. That on the finding of the inquiry officer, the charge was proved that he remained absent without obtaining leave in advance. That the order granting leave was made after the order terminating the employment, and it was made only for the purpose of maintaining a correct record of the duration of service and adjustment of leave due to the delinquent officer and for regularizing his absence from duty. This court's attention was not invited to any rule governing the respondent's service conditions under which an order regularizing absence from duty subsequent to termination of employment had the effect of invalidating termination. Thus, this court concluded that it could not be held that the authority, after terminating the employment of the delinquent officer, intended to pass an order invalidating the earlier order by sanctioning leave so that he was to be deemed not to have remained absent from duty without leave duly granted. Para 6, my lord. Bakshi Singh case arose out of a suit filed by Bakshi Singh, who was a police constable in Punjab but was dismissed from service on so-and-so after a regular departmental inquiry on the charge of unauthorized absence from duty. This order was challenged on several grounds, and the trial court decreed the suit on the basis that the order of dismissal could not have been passed by the defendants in as much as they themselves had regularized and treated the period of plaintiff's absence from duty as period of leave without pay. And they could not legally say that he was guilty of misconduct for unauthorized absence from duty. Having found that it was not a case of misconduct of gravest kind, the lower appellate court, while upholding the finding of the trial court, remanded the case back to the disciplinary authority for passing a fresh order of punishment Second appeal preferred before the High Court was dismissed in limine. In those circumstances, this court noticed that once it was found as a fact that the charge of unauthorized absence from duty did not survive, we failed to understand how the lower appellate court could remand the matter back to the punishing authority for passing a fresh order of punishment. It was further noticed that the finding of the trial court was that the proper opportunity of hearing was not given, and the signature of Bakshi Singh was obtained under duress during departmental proceeding. And when that finding remained intact, there was no occasion to remand the case to the punishing authority merely for passing a fresh order of punishment. It is in these circumstances this court ultimately passed an order to set out at para 11 of the judgment, which is as under. It will be noticed that the trial court recorded a categorical finding of fact that the proper opportunity of hearing was not afforded to the respondent in the departmental proceeding, and that his allegation that his signatures on certain papers during those proceedings were obtained under duress was not controverted, as the state of Punjab had laid no evidence in defense. The trial court also recorded a finding that unauthorized absence from duty having been regularized by treating the period of absence as leave without pay, the charge of misconduct did not survive. It was with this finding that the suit was decreed. The lower appellate court confirmed the finding that since the period of unauthorized absence from duty was regularized, the charge did not survive. But it did not say a word about finding related to the opportunity of hearing in the departmental proceeding. Since those findings were not specifically set aside and the lower appellate court was silent about them, the same will be treated to have been affirmed in the fact of these findings. It was not open to the lower appellate court to remand the case to the punishing authority for passing a fresh order of punishment. The High Court, before which the second appeal was filed by the state of Punjab, did not advert itself to its inconsistency, as it dismissed the appeal summarily, which indirectly reflects that it allowed an inconsistent judgment to pass through its scrutiny. Therefore, the appeal in Bakshi Singh case was allowed. It is only in the head note of the report that the question whether an employee could be held guilty of misconduct on the basis of unauthorized absence is set out as decided in the trial court and affirmed by the first appellate court. And not from the judgment of this court, such a conclusion can be drawn, since there is no consideration or discussion at all, much less any declaration of law is made by this court on this aspect of the matter. This court, in that case, really considered the scope of power of remand, made the order as set out above, and did not in fact consider the question whether the view expressed by the first appellate court in affirming the order of the trial court was justified or not, but proceeded on the basis that on the conclusion reached by the first appellate court, whether remand to disciplinary authority is permissible in law, and recorded its finding. Therefore, the decision of this court in Bakshi Singh case is not an authority for the proposition that the order terminating the employment cannot be sustained, inasmuch as in the later part of the same order, the disciplinary authority also regularized unauthorized absence from duty by granting an employee leave without pay. In our view, there is no conflict with in this regard with the decision in Harihar Gopal's case. So the proposition of law, my lord, that was laid down in Harihar Gopal's case, that was upheld by the three judges bench, and the ratio of Harihar Gopal's case is at para 5, my lord. I have just read that it was made only for the purpose of maintaining a correct record of the duration of service and adjustment of leave due to the delinquent officer, and for regularizing his absence from duty. Now, the next judgment I am relying on is 2004 7 SSC 574. The relevant paragraphs will be paragraph 10 and 12, my lord. Same Harihar Gopal has been relied on here also, my lord. Para 10, great emphasis was laid by the learned counsel for the respondent employee on the absence being treated as leave without pay, as was observed by this court in state of MP versus Harihar Gopal by a 3-judge bench of this court. Even when an order is passed for treating absence as leave without pay after passing an order of termination, that is for the purpose of maintaining correct record of service, the charge in that case was, as in the present case, absence without obtaining leave in advance. The conduct of the employee in this case is nothing but irresponsible in the extreme and can hardly be justified. The charge in this case was misconduct by absence. In view of the governing standing orders, unauthorized leave can be treated as misconduct. Para 12, the tribunal proceeded in all these cases on the basis as if the leave was sanctioned because of the noted leave without pay. Treating as leave without pay is not same as sanction or approved leave. In the instant case also, my lord, in the penalty order, the leave was treated as earned leave. It was not the leave was sanctioned as earned leave, my lord, in the impugn order. So in that view of the matter, there is one more judgment, my lord, PL Singla, that is 2008 8 SCC 469. Relevant paragraphs will be, my lord, para 11, 12,
11, 12.
11, 12, and 13, my lord. As well as 14, my lord. 11, 12, 13, and 14, my lord. The proposition of law is same, my lord. So my humble submission is, sorry.
Yes. Yes.
So my humble submission is that, my lord, so far as the question raised by the petitioner that you have treated the period of unauthorized absence as earned leave. Now you cannot impose penalty or you cannot initiate a departmental proceeding. My conduct is not a misconduct, my lord. That is not the correct proposition of law, as my lord lordship has seen. Apart from that, my lord, this entire story of treatment, medical certificate, these all are afterthought, my lord. The only idea was to fled away from here and to get married at Mumbai, my lord. So the petitioner, my lord, he did not say the correct facts before the disciplinary authority, nor he is saying the correct facts before this honorable court also. Apparently, my lord, there are difference in dates of the medical certificate, my lord. When he first in his application, he said that I am going to Delhi, then he shifted to Mumbai. My lord, both the petitioner's disease is different. One suffering from skin disease, one is suffering from respiratory problem. Both treated under the same doctor, my lord. Subjects are different, my lord. That is common sense. So in my respectful submission, what is the penalty imposed? It's a minor penalty, my lord. And it's a settled law that in minor penalty proceedings, my lord, the disciplinary authority not required to, my lord, initiate a regular inquiry. Even then a regular inquiry was initiated. So in my humble submission, my lord, neither the penalty is disproportionate, nor there is any procedural infirmity in the entire inquiry, my lord, nor the ground urged by the petitioner with regard to, my lord, treating the period of unauthorized absence as unleave is the correct proposition of law, my lord. The correct proposition is that, my lord, this is done, this has to be done for maintaining the record of the employee. Otherwise, it will be a break in service. If that period is not treated, that it will be a break in service. It will culminate in dice non. That entire period will skip for the purpose of pensionary benefit and other benefits, my lord. So in my humble submission, my lord, there is no merit in the writ petition, my lord. This is liable to be dismissed, both the cases.
Just let me see the relevant part of the other writ petition. What
Yes,
is the
my lord.
penalty involved here?
My lord, I'll just briefly point out the relevant dates. I'll not take, my lord. Application for commuted leave rejected, but page 31. She submitted a leave application, page 24, through email.
First of all, where is the order of penalty?
Order of penalty, your lordship will find page 96.
Same date.
Same date, my lord. Last paragraph. Only difference is that here, that period was treated as committed leave as prayed for. And in the case of the first petitioner, it was earned leave. Deeply okay for the patient hearing.
The facts stated in those rulings are not applicable in this case, madam. Because here one simple thing, madam, whether the absence is unauthorized or not. If the employee has given due information to the employer that he has to go to Bombay and he has paid for unleave also from Saturday. Thereafter, at the end of that period, he has filed another application that my leave may be extended from here to here. Thereafter, another application was filed that my leave shall be extended from here to here. Three applications. The first application, the first matter 2 days, he was in casual leave. From my lord 23 to 24, he was casual leave. 25, 26 was government notified holiday. And he gone on 27. And on the same day, he has filed the application. When the authority was duly informed whether that absence can be treated as unauthorized or not, my lord. If I am not giving information to the employer, then it should have been unauthorized, my lord. But I have given my application was rejected after 2 days, thinking that your application is not supported by medical certificate. Agree. But I am going for treatment, ongoing, on the same day I have filed the application, then how medical certificate I can annex, my lord. Moreover, it is not the duty of the employer to reject the application for non-annexing that. At least he should have been directed to furnish your medical certificate. Otherwise, your leave would not be granted. One thing, my lord, the leave is not the bounty of the employer, my lord. It is not the bounty. It is that every government servant earned 20 days leave in a year, my lord. That is called earned leave, my lord. Every year he earned 22 days leave and he can avail when required. Here, my lord, your lordship see the page 71. Page 71, he has my page 71, my lord, he has this is their letter, my lord. Apply letter. He has 289 days earned leave. On the date of his application, he has 20 earned leave. When I have earned leave, I have right to avail it, my lord, when necessary. So I am giving information to the employer, my lord. If I am not giving information, not filing earned leave, then my absence would have been treated as unauthorized, my lord. At this step, some first application was filed, that was rejected. At the end of the period, I have filed 3 applications was filed, my lord. First is, my lord, page 24, second is page 43, third is page 48, my lord. 3 applications, first was rejected, second and third, no action was filed, my lord. Thereafter, he has given proper notice. As he was busy there, he did not reply at that time. But information was there, my lord. I am here. In spite of knowing the fact that the information has, or the employer has made application for the earned leave, but just to magnify the thing, they have given paper publication. That where he is. It is very ridiculous, my lord. The employer has given information that I am here, I am paying for earned leave. But in spite of that, the employer has given paper publication in 2 to 3 papers, and that where you are not known, you come and join. All these are just to magnify the things, my lord, out of any personal jealousy or bias, my lord. So thereafter, when he comes, departmental proceeding was drawn, he has given the reply. Thereafter, after the inquiry officer has submitted the report in the, my lord, and the regarding, my lord, the filing of the criminal case, it was in page 85. High Court has paused it, my lord, that FIR, my lord. And High Court has paused it, stating that it is absolutely false, my lord. And thereafter, inquiry officer has, after considering his written statement, inquiry officer has submitted report. And in the report, it is, my lord, page 93, para, third, second, third. Now, considering the materials that had suffered on the discussions of the relevant documents and statement of witnesses in the inquiry, it is established that the delinquent staff Ananta Prasad Siyastadar MSCT Juburi being in responsible positions in the gross negligence, he had only been absent, unauthorized from his duty, but had been outside the headquarters from Iman to Iman. So when he has given information, there cannot be a question of unauthorized action, my lord, which amounts to misconduct for the purpose of this purpose of the proceedings, and this determination and the breach of the official discipline is also thus unauthorized, established. Hence, it is established that the delinquent staff Ananta Prasad had violated the rules so and so of the Assam Service Discipline Institute 1964, and in these two intimates. The order of suspension dated 26/8/2016 passed against the delinquent staff Ananta Prasad MSCT Dhuburi stand vacated, and the period of unauthorized leave from 27/6 to 26/8/2000 is to be adjusted with the PR for earned leave made earlier. PR for earned leave made earlier. That means he has made application for earned leave earlier, my lord. That was granted, my lord. It is not that he has filed this application for granting leave. So when he has made application, he has been in his credit. Biasly, this leave was rejected. By rejecting, it was given paper publication, and thereafter the charge was sent, departmental proceeding was drawn, and he was suspended. All these things have been done without any fault of the employer. Because my right has been curtailed, I have right to exercise my leave, my lord, which I have earned, my lord, not a gratuity of from the employer, my lord. It is not a boundary from the employer, my lord. My right cannot be curtailed. And similarly, one can enjoy earned leave, and I can enjoy commuted leave. Commuted leave is also part of the just like earned leave. And Anjuma Begum also same side of the same days of that is commuted leave in her credit, and it was also rejected, subsequently granted, my lord. So I humbly pay your lordship to consider when the employer action with proper information to them from time to time, whether it can be treated as unauthorized. If it is unauthorized, how subsequently leave was granted, my lord? On the basis of the earlier application, not that he has given application later, my lord. So it is good. The whole thing is going to bias my lord, because one India reply they have once stated that in the casual leave application he has not stated the result. It is not necessary. Casual leave, if I cannot come today, I can give it to order because of certain circumstances I could not come. There no reason is to be recorded in that. In the earned leave application cannot be rejected on the ground that it was not supported by the medical certificate. Employee should be directed that you submit your certificate, otherwise leave will not be granted. Even after joining of the employee, taking the medical certificate from him, the leave can be granted, my lord. But here, after 2 days, 27, they have 27, they filed the application, and 29, it was rejected. You are page 31.
Mr. Sharma, I think you are repeating the same thing again and again and
No,
again.
no, I want to.
How
show
many
you
times
that-
you want to repeat? Tell
Show
me.
you lots of the order rejecting the bail. In the rejection order, it is not stated that you have gone to marriage or gone to Bombay to marriage on Juma Begum for that leave was granted. It is not. It is stated that you are hereby informed you to have been unauthorized absent from duty of the even till today. You are also unauthorized absent from station headquarters. The undersigned has received your application seeking unleave with effect from 27 to 28 of 2016 through email, which was sent on 28, 2016 at 10 a.m. Your application for unleave is not supported by the medical certificate. That is why I have just gone and placed the certificate, my lord, the leave application. How I can place the certificate?
Which certificate? Which certificate?
Medical
Which is the
certificate.
show me the certificate.
Medical certificate,
Yeah, which one? Is it there in the record?
my lord.
Is it there in the record?
No, I'm reading the order. Order.
No, the
rejection
medical certificate you want to rely upon. Is it there in the record?
Or it is record.
Which part? Which page?
It is record annexure 1. Page 20. Page 23, my lord. Let me see. It is file letter, my lord, 23/9/2016. After coming back
This
to
certificate is dated 23rd of May 2016.
No, it is 9, my lord, 23/9/2016.
Please come to the previous page, page 22. What is the date given there?
It is 7 here, 23/7/2016.
23/7 in page 22.
It is page 22.
Mhm.
Page 22. 22. Yes, 23/7.
আপনার সাথে হাতে দিয়ে লেখা আছে স্যার আপনি ফটো কপি
23/7, my lord. 23/7.
Here it is written 23/5.
Mistake, what is 23/7, my lord? Anyhow, he has submitted medical certificate, my lord. Sorry, I'll leave on my personal expense also, I am submitting a lot. I'll leave, it is the matter of right, my lord. It's a matter of right on the employer.
Mr. Sharma, you have argued that twice or thrice. There is no point repeating
Right,
the same
I'm
thing.
sorry. That is why my submission, my lord, his absence is not unauthorized, my lord. It is the authorized and subsequently his leave was granted, his suspension was vacated. He was giving all the benefit. But only was granted on the basis of the earlier. My penalty is minor, my lord. But the two increment, it will withhold his pay, my lord. When the two increments are stopped, his pay will be minimized, my lord. And it will subsequently, he will be reserved, my lord. Actually, not only today, but after a few years, he will be reserved, my lord. And his pensionary benefit will be affected, it will be reduced, my lord. That is the effect of reducing of the my lord. So my humble submission, my lord, there is nothing illegality, no misconduct is proved, my lord. So the order, as per the page 98, my lord, last para, your I already seen it.
Item 2 and 3.
Last para, that is the all things has been given. On Juma Begum also, all things has been given that they were regularized, suspension was vacated, leave was granted, they were given for the event of suspension period. So nothing remains, my lord. In this case, the provision of misconduct is my lord ridiculous, my lord. So my submission, my lord, the petition may be allowed and order may be satisfaction.
All right, heard Mr. K. Sharma, learned counsel assisted by Mr. S. Boro appearing for the petitioners in both these read petitions. Also heard Mr. H. K. Das, learned standing counsel, Guwahati High Court, representing the respondent numbers.
Respondent number 2 and 3, my lord.
2 and 3. Mr. J. K. Goswami, learned government advocate Assam has appeared for the respondent numbers.
1.
For the respondent number 1 in both these cases. Full stop. the writ petitioners, the writ petitioners in the aforesaid cases are related to each other as husband and wife, being aggrieved by the order of the disciplinary authority, both dated 1/8/2017, imposing the minor penalty of withholding 2 increments so as to come into effect from the date of the order by regularizing their period of unauthorized absence against the applications for earned leave, commuted leave. The instant these writ petitions have been filed inter alia, containing that after regularizing the period of absence against earned leave, commuted leave, there was no occasion for the authorities to impose the minor penalty of withholding of 2 increments, as has been done, as have been done in these cases. Full stop. The facts and circumstances of involved in both the writ petitions are identical, with the only exception that while the writ petitioner in WPC number 6490/2017, that is Ananta Prasad, that is Sri Ananta Prasad, had applied for earned leave, his wife Anjuma Begum, who is this Srimati Anjuma Begum, who is the petitioner in WPC number 6492/2017, had applied for commuted leave for the same period, had applied for earned leave for the period from 27/6/2016 to 26/8/2016. His wife, namely Srimati Anjuma Begum, who is the petitioner and so and so, had applied for commuted leave for the same period. Full stop. For the purpose of disposal of both these writ petition, I propose to refer to the facts involved in WPC number 6490/2017. Full stop. The writ petitioner Ananta Prasad, while serving as the Sharistadar in the office of member Motor Accidents Claims Tribunal, Dhuburi, had remained absent from duty from the period from 27/6/2016 to 26/8/2016. Full stop. Full stop. On 27/6/2016, the petitioner had sent an application seeking earned leave for the period from 27/6/2016 to 28/2016 by means of email addressed to the presiding officer of the MSCT Dhuburi. Full stop. It appears that the petitioner had left for Mumbai on 24/6/2016 along with his wife Srimati Anjuma Begum. Full stop. On 25/6/2016, the brother of Srimati Anjuma Begum had lodged an Ejahar with the Dhuburi police station, alleging that the writ petitioner had abducted Anjuma Begum and had threatened with dire consequences by demanding a sum of rupees 15 lakhs from him. Full stop. The writ petitioner and his brother Bankim Prasad had abducted so and so and demanded rupees 15 lakhs so and so. Full stop. Based on the Ejahar dated 25/6/2016, Dhuburi PS case number 658/2016 was registered on 25/6/2016. under section 364 bracket A bracket close oblique 34 of the IPC. Full stop. In the meantime, taking note of the unauthorized absence of the petitioner from duty, the presiding officer of MSCT Dhubri, that is the respondent, is the respondent here?
Yes, my lord. Respondent number 3, my lord.
That is the respondent number 3 had issued a notice to the petitioner indicating that his application for earned leave was not supported by any medical evidence and that he had unauthorizedly remained absent from duty and had also left the headquarters. Therefore, the petitioner was asked to immediately report for duty by reiterating that his absence from duty since 27/6/2016 is unauthorized. First of all, when the petitioner had failed to respond to the notice dated 29/6/2016, a show cause notice was addressed to him asking him to show cause as to why a departmental proceeding should not be initiated against the petitioner. First of on 21/7/2016, the petitioner had sent his reply by stating that he had to leave the headquarters due to medical emergency, and since as a result of which he could not produce the supporting medical documents. However, on completion of medical checkup and treatment, he would submit all the medical certificate. Accordingly, the prayer for grant of earned leave and station leave permission was reiterated by the petitioner, even in his reply dated 21/7/2016. The aforesaid explanation of the petitioner was not found to be acceptable, as a result of which the respondent number 3 had initiated a departmental proceeding against the petitioner. On conclusion of the departmental proceeding, the inquiry officer had submitted his report, wherein it has been held that the petitioner has acted in an irresponsible manner and in gross negligence of his duty by remaining unauthorizedly absent from duties outside and proceeding outside the headquarters for the period with effect from 27/6/2016 to 26/8/2016. Full stop. Full stop. Based on such finding of the inquiry officer, the impugned order dated 1/8/2017 was issued. The operative part of the order dated 1/8/2017 is reproduced herein below for ready reference. You'll get it in page 98, double tick to double tick. Full stop. It would be needless to mention herein that a similar proceeding was initiated against the writ petitioner in WPC number 6492 of 2017, who was serving as a copyist under the MSCT Dhubri at the relevant point of time, with the only exception that instead of applying for earned leave for the aforesaid period, the Srimati Anjuma Begum had applied for grant of commuted leave. Full stop. Full stop. Assailing the impugned order dated 1/8/2017, Mr. K. Sharma, learned counsel for the petitioners, has strenuously argued that his clients had intimated the authority and had also submitted their respective applications for earned leave and oblique or commuted leave on 27/6/2016 itself. That is the date on which they had proceeded for treatment, full stop. Since 25th and 26th of June 2016 were government holidays. Hence, and in view of the fact that both the petitioners had submitted their applications for leave, it cannot be argued that they were absent unauthorizedly. Full stop. According to Mr. Sharma, earned leave oblique commuted leave are earned by the employees by dint of their continuous service, earned by the employees under the rules by dint of their continuous service in the department, and therefore availing such leave is a matter of right which cannot be denied by the authorities. Full stop. Under the circumstances, once the employees had applied for the leave and authorities were aware that they were in need of earned leave oblique commuted leave, the respondents were duty bound to grant such application without raising any further question. Full stop. It is also the submission of Mr. Sharma that since the period of absence of both the petitioners were regularized by the authorities by granting them earned leave oblique commuted leave, as the case may be, the question of misconduct oblique unauthorized absence from duty did not arise at all, and consequently there was no occasion for the disciplinary authority to impose the minor penalty of withholding the 2 increments imposed upon the petitioners. Full stop. Mr. Sharma has urged that the minor penalty of withholding of 2 increments would have a cascading effect throughout the career of the petitioners and even after their retirement, on their pensionary benefits, and therefore therefore the order of penalty deserves to be interdicted by this court. Full stop. Responding to the above arguments, next para, Mr. Das, learned counsel for the respondent numbers 2 and 3, has argued that merely because the applicants had submitted, the writ petitioners had submitted applications for leave, this same cannot lead to the conclusion that such applications were automatically granted. As a matter of fact, submits Mr. Das, by issuing the notice bracket S bracket close dated 29/6/2016, both the petitioners were informed that their applications seeking leave had been rejected on the grounds stated therein. First of all, after such communication, it was incumbent upon the writ petitioners to immediately report back from duty, which they failed to do. Full stop. Mr. Das has further argued that the petitioners have not only remained unauthorizedly absent from duty for a long period of time, ranging from 27/6/2016 to 26/8/2016, but have also distorted the facts and presented a false story before the authorities. Full stop. According to Mr. Das, both the petitioners had left for Mumbai to get married therein, and thereafter they spent time to settle down in their married life, but had incorrectly projected before the authorities that they were in need of medical treatment, which is far from true. Full stop. By referring to the solitary medical certificate relied upon by both the petitioners, Mr. Das has argued that while the writ petitioner in WPC number 6490/2016 had claimed that he was suffering from bronchitis and breathlessness. His wife, namely Srimati Anjuma Begum, has claimed that she was suffering from skin disease, but both the petitioners had apparently consulted the same doctor, that is Dr. Vinod
Vinod S. Shirodkar.
Vinod S. Shirodkar, MBBS, bracket BOM, and that too on 23/7/2016, bracket type test 23/5/2016, which is more than a month after they had apparently left the headquarters of the left their headquarters, full stop. Mr. Das has also pointed out to the other discrepancies in the projections made by the petitioners, in as much as while the leave application mentions that he had proceeded for Delhi, the other documents show they had proceeded for Delhi. The other documents go to show that they went to Mumbai. Under the circumstances, Mr. Das submits that this is nothing but total irresponsible behavior of the petitioners, and therefore the authorities were wholly justified not only in holding the departmental proceeding, but also in imposing the minor penalty, full stop. Insofar as the argument regarding regularization of the period of absence of the petitioners having a vitiating effect on the order of penalty, Mr. Das has argued that such a recourse had to be taken only to keep the service record intact and also to avoid further prejudice being caused to the petitioners in the matter of computation of their service benefit and pensionary benefits. Full stop. The same cannot, in the submission of Mr. Das, have any bearing in the order of penalty which has been issued to both the petition, which has been imposed upon both the petitioners based on categorical finding of misconduct recorded by the inquiry officer. Full stop. In support of his above arguments, Mr. Das has placed reliance on the decisions rendered by the Supreme Court in the case of Mansingh versus Union of India and others, reported in 2003, bracket close 3 SCC 464. Then next is Delhi Transport Corporation versus Sardar Singh, reported in 2004, bracket 7 SCC 574. And in the case of State of Punjab versus Dr. P. Full stop L. Full stop Singla, reported in 2008, bracket load 8 at SCC 469. Full stop. I have considered the submissions advanced by learned counsel for both the parties and have carefully gone through the materials available on record. Full stop. As would be apparent from the facts alluded above, there is no doubt or dispute about the fact that both the petitioners who were working under the establishment of respondent number 3 had remained absent from duty with effect from the period from 27/6/2016 to 26/8/2016. First up, there are documentary evidence not only to show that during that period they were in Mumbai in the state of Maharashtra, but the materials of evidence, available on record also demonstrate that the petitioners got married at Mumbai, Maharashtra, under the provisions of the Special Marriage Act. Special Marriage Act, what is the
52 page?
Page
52. Section 30.
Annexure 11, page 31.
It says section 13.
Section
Section 13, page 52. Just
Special
below.
Marriage Act 1954. Full
Yes.
stop.
Excellent.
From the above, it is amply established that the whole purpose of the petitioners going to Mumbai is to get married away from their family members so as to avoid the opposition, apparently opposition from the family from the family of Srimati Anjuma Begum. First up. Next, as noted above, both the petitioners have relied upon a medical certificate issued by a general practitioner from Mumbai. First up. However, there is nothing on record to show that both or either of the petitioners were suffering. No, there is nothing on record to show that the petitioners were suffering from any such disease prior to 27/6/2016, which would require superior medical attention at Mumbai. Full stop. It is also not understood as to why the petitioners had to ignore the facilities of specialized treatment available in the state capital at Guwahati, that is the Guwahati Medical College Hospital, having specialist doctors, and to reach Mumbai to avail treatment from a doctor who did not have any specialized degree. Be that as it may, on a careful examination of the facts and circumstances of the case, this court is unable to accept the submission of Mr. Sharma that the petitioners had to leave for Mumbai so as to receive urgent medical treatment, as there is no such evidence to support such a contention. If that be so, and considering the fact that there is no dispute about the fact that both the petitioners had remained absent from duty during the period from 27/6/2016 to 26/8/2016, there can be no doubt or dispute about the fact that the conduct of the petitioners were irresponsible and therefore was sufficient to invite disciplinary action from the authorities. Full stop. Insofar as the argument next para of Mr. Sharma that since that the that earned leave / committed leave is a right of the employee which he or she acquires under the rules, there can be no doubt about the fact that each employee will be entitled to apply for leave as may be permissible under the rule. Full stop. However, this court cannot be oblivious about the fact that save and accept casual leave, grant of leave is the matter of discretion by the employer, and if such discretion is exercised in a reasonable manner and after taking due note of the facts and circumstances of each case, it cannot be said that the grant or rejection of earned leave / committed leave would be illegal merely because it does not meet with the expectation of the employee. Full stop. Full stop. In the present case, having regard to the facts and circumstances of the case, there is nothing to indicate that the employers had acted in an arbitrary and illegal manner while declining the application for earned leave / committed leave made by the petitioners. Full stop. Coming to the last question as to whether the regularization of the period of absence of the petitioner by treating the period of absence as on leave would have a vitiating effect on the order of penalty. This said aspect of the matter has also been dealt with in several decisions of the Supreme Court and has been held that merely because the period of absence is regularized, the same would not automatically set at naught the order of penalty, which may include an order of dismissal from service. First up, after summing up the law laid down in various relevant decisions, the Supreme Court has made the following observations in the case of Dr. P.L. Singla, bracket Supra, as relied upon by Mr. Das, which is reproduced herein below for ready reference. You have to quote para 14 of Singla. Full stop. Full stop. In view of the ratio laid down in the case of Dr. P.N. Sigla, I find force in the submission of Mr. Das that the subsequent order to regularize the period of absence from duty of both the petitioners was meant to set the record straight so as to avoid any future complications in the matter, as otherwise the same would amount to a break in service, full stop. In other words, by accepting the leave applications with a post-dated approval, what the authorities have done is merely treated that period of unauthorized absence as on duty for the purpose of their the service record, full stop. The same does not in any manner exonerate the petitioners from the charge that they had left the headquarters unauthorizedly and have acted in an irresponsible manner by suppressing true facts and without offering any lawful explanation for their absence from duty. For the reasons stated here in above, I do not find any justifiable ground to interfere with the orders of penalty imposed by the authorities. Since there is no allegation in the writ petition as regard violation of any procedural safeguard or principles of natural justice, this court finds that there is no scope to grant any relief to the petitioners in both these writ petitions. The writ petitions are accordingly held to be devoid of any merit and are accordingly dismissed. Parties to bear their own cost.
Lordship, on the last location directed to whether any post is vacant or not in the parliamentary force.
Sorry, what is it?
On the last location directed to the CGSC to produce whether any post is vacant or not in the parliamentary force.
Election process was 2018 lawsuit. Lordship, find the finding of the opinion of the civil doctor, Lordship.
Just a minute. No, Mr. Chakravarti, there are diametrically different opinion. One civil doctor said there is nothing. The medical board of yours says is,
Lordship, the opinion of the civil doctor, Lordship, will find at page 35, Lordship.
page 35.
Yes, I will find. Serial number 3, Lordship. Type copy, that is the type copy, Lordship.
Yes.
Serial number 3, in my opinion, this is an error of judgment due to the following reason. Start with the sentence, Lordship. If it is minimal of any of and for hypospadias without any content. So it's not a concrete, not a positive opinion. Start with the if, Lordship. And Lordship, we follow the guideline of the Lordship, we have a guideline. And as per the guideline, Lordship, hypospadias can be a ground for its rejection.
Then Lordship, that page 42,
6 months.
page 42 is
Let
an
me choose. No, Mr. Bejbora, the court will not say whether he is fit or unfit.
Lordship.
The court will only see the procedure adopted in this case, whether it is in accordance with the rules or not.
Lordship,
If it is found it is in accordance with law,
I,
you are going home.
yes, Lordship, my contention is there is a no specialist doctor in the appeal medical board conducted by the respondent authority. There is not a civil surgeon nor any urologist in the appeal medical board.
And Lordship may also looked into the introductory part and the aims objection of this framing the guideline. That we want to appoint someone that becomes of the hardest nature of the job. It's a 24 hours duty in the security Lordship job. So we want fittest person to be in the job. Aims and objectives and the introductory part, Lordship.
So this is a ground to declare someone as medically unfit, and the medical board constituted by the authorities have found you to be of that category.
Lordship.
What
But
to do by
Lordship,
High Court? What will the High
Yes,
Court do?
my contention is, Lordship, in the appeal medical board, there is a no specialist doctor in the relevant field. So my prayer is, Lordship, can you remand back the matter to the department, constitute a medical board with an expert in the relevant field.
No, but why do you need a specialist doctor?
Lordship, that only the specialist doctor will found whether this disease exists or not.
Even the opinion he is relying, that is also not.
And the
Which
case-
is the opinion of
Yes,
medical
Lordship.
board?
There is medical board opinion, Lordship, that the first opinion, Lordship, case 32,
Is 32.
case 32, this is the first medical board conducted by the respondent authority. Case 32. Annexure 3. We found him unfit due to the reasons mentioned below, granular hypospadias. Thereafter, I preferred an appeal.
Then what
Then
is the
Lordship,
opinion of the
case-
review medical board?
Review medical board, Lordship, that opinion is
Page 39, Lordship.
case 39.
Hard copy is
Clause
at page
3.
41.
Clause 3B.
So review medical board has also found you to be.
Yes, Lordship. Lordship, prior to that, the page page 35 annexure 4. Annexure 4, I had approached the civil doctor, urologist, Dibrugarh Medical, Assam Medical College. Lordship, he found that if it is minimal of for the hypospadias without any complaint.
Page 40,
Page 35. Clause 3,
45. Where is 45?
35,
35.
clause 3, which I have read, Lordship.
No, but then general, they know the army, the doctors of the force, they know what is the requirement of the rules, what is the service conditions.
Yes, Lordship, I am very agree with that.
You can't help it.
And even in the page 7, annexure 7, page 42, the civil doctor also certified that there is no hypospadias is detected. Page 42, annexure 7. So my prayer is very limited, Lordship. So
No,
there-
this is the opinion of civil hospital doctors
yes,
versus
Lordship. There is a dispute.
army doctor. This dispute we can't entertain. Is there any plea of malafide?
Lordship,
Are you saying that they are doing it to discriminate you against someone or something like that?
Lordship, my contention only is that there is a no specialist doctor in the while appeal medical board was conducted. And even in that affidavit also they have not admitted.
No, but where is the requirement of having a specialist doctor?
Lordship, only the specialist doctor will determine whether
That is your opinion.
that much.
The process is arbitrary, discriminatory, then the otherwise, what can the read court do in these matters? Because they will know who is fit, who is unfit. They will have their procedure.
Yes.
We can't say that, no, you can't have this procedure, you have that procedure. Tomorrow somebody will say that you have a fashion designer in the group because I feel so. Can you have that? What is our jurisdiction to get into all these things?
Whether procedure has been followed or not. But in the appeal medical board, there is a no specialist doctor.
Where is the requirement to have a specialist doctor?
So, Lordship, even in the memo, even in the says, Lordship, that page 30. Then in the guidelines says when there is an appeal
Mr.
conducted.
Bezbula, this time it's over. We have seen it, there is no discrimination. These things can't be reopened like this. Heard Mr. H. Bezbula, counsel for the petitioner, also heard Mr. B. Chakravarti, and CGC appearing for the respondents. Mr. The writ petitioner hearing had participated in the recruitment process for appointment of
Constable GD in Central
Constable-
Armed Police Forces.
GD in the Central Armed Police Forces, including the NIA, Secretariat Security Force, and Riflemen bracket GD bracket close in the Assam Rifles. Full stop. The petitioner had cleared the written examination as well as the physical efficiency test, but the medical test, which is conducted at the final stage, had found the petitioner unfit to be appointed as a GD, a constable GD, on account of the fact that he was suffering from the medical deficiency, namely within course granular GRA and NULAR, that was a hypospadias, HYPOSPADIS. Would you like a spelling? You'll see in page 32. Stop. First stop. The petitioner had preferred a review. A petitioner had appealed before the review medical board against the opinion of the medical board, declaring him as an unfit candidate. But even the review medical board had confirmed the opinion of the medical board and declared him as unfit on the same ground. Full stop. Assailing the said decision, the petitioner is before this court, inter alia contending that the doctors consulted by the petitioner in the civil hospitals have found him not to be unfit due to the aforesaid disease, and therefore had the authorities included a specialist in the medical board, review medical board, in all probability, the opinion of the board would have been different, thereby paving the way for the petitioner to get appointed in the force, full stop. Mr. B. Chakraborty, learned CGC, has obtained instruction to submit that as per the guidelines prepared by the authorities, so and so, a granular hypospadias is a medical deficiency which is sufficient to declare a candidate unfit. Full stop. Mr. Chakraborty submits that there are discrete reasons for including certain diseases as the ground to declare a candidate unfit, since the authorities do not want to fill up the force with persons who may be unfit to render duty in various harsh conditions, and also so as to obviate the possibilities of early retirement of large number of constable in the force, full stop. Mr. Chakraborty further submits that the advertisement was issued in the year 2018 and all the vacancies have in the meantime been filled up. As such, there is no scope for the authorities to accommodate the petitioner at this stage. Full stop. The first and foremost query, next para, which the first and foremost issue that calls for resolution in this proceeding is as to whether the disease, namely so-and-so, is one of the medical conditions named under the guidelines which can declare a candidate to be unfit for induction into the force. Full stop. The answer to the said query is undoubtedly in the affirmative, since the guidelines clearly provide so. Full stop. The next query would be as to whether the authorities have flouted the requirements of the rules while subjecting the petitioner to medical examination. Full stop. Here, the court finds that the answer has to be in the negative, since there is no allegation made by the petitioner that the medical board, review medical board, had not complied with the mandate of the rules while examining examining the petitioner from the point of medical fitness. Full stop. The petitioner's counsel has urged that they ought to have included a specialist in the medical board, but has failed to point out any such requirement under the rules. Full stop. Insofar as the opinion of the doctors in the civil hospitals are concerned, their opinions, apart from being tentative in nature, cannot have a clinching value in this case, since the mandate of the medical board constituted by the respondents is with reference to the requirements of the guidelines, keeping in mind the requirement of the force in general, and therefore may adhere to different standards as compared to a doctor in a civil hospital. So stuff. Even if there is a difference in opinion between the two set of doctors, the opinion of the medical board constituted by the respondents in the opinion of this court would have primacy, and therefore would be of paramount importance in this case. Since the petitioner has not alleged any arbitrary or discriminatory treatment from the authorities, this court is of the opinion that there is no scope to issue a writ of mandamus directing the respondents to appoint the petitioner in the attendant facts and circumstances of the case. Consequently, this petition fails and is thereby dismissed.
Much of it.
Item 5 to 9.
May please, Lord, I'm appearing in 5 and 6, my lord.
6 and 7.
6 and 7. Oh, 5 5 you mean that?
I am appealing item number 9 here.
What are these matters?
But these are matters, my lord, by the Ayurvedic doctors. They want an parity with the allopathic doctors for regarding enhancement of age of superannuation.
This will take some time.
It will take some time.
We'll hear it at 2. Mr. Chaudhary is also there.
Lordship, he is there, Lordship.
He is there.
And moreover, Lordship.
Lordship, Mr. B. Gugoi is ending the case, Lordship. He is on lakes in court number 17. There
We'll
is-
take it up at 2. At 2. At 2, you are available?
I will.
All right, at 2.
Much obliged.
Item 10.
In this case, I am paying adjournment.
On the prayer and counsel for the petitioner, this matter stands adjourned for 2 weeks. Mr. T.C. Tutel and additional government advocate Assam is present on behalf of the state. Yes.
Item 11.
Additional senior government advocate.
May it please your lordship. Lordship, this matter pertains to excess reservation in SC category for PWD candidates for the post of junior engineers in PNRD department. Lordship, this matter was heard at length by another court, and in the meanwhile, certain records were supposed to be produced by the respondents. Lordship, which are yet to be produced.
No, earlier occasion, Lordship, we have produced the record also. And
This matter is parted before on the bench.
no,
Not reflected, Lordship. It is not reflected as part.
not reflected. Not part of it.
Along with item 28.
Yes. Lordship, there is an impediment also in this matter.
No, today what is to be done? Impleading whom?
I appeared for the applicant in I number 796, Lordship.
Yes,
I-
what is this
I
IFO?
am the selected candidate, Lordship. I am visually impaired, Lordship, and I have been selected, but due to the interim order passed in the main petition, Lordship, I have not been able to join, Lordship. So I bring.
In fact, what on the first day, one interim order was passed. Saying the appointment of 3 candidates, one simpliciter, one FC woman, one executive. One FC woman has already been allowed to join, not to find subsequent order lawsuit. Now he is executive lawsuit. He is an eye for his imprisonment as well as for vacating the.
There are 3 vacancies.
There were 320 vacancies.
And how many petitioners?
One.
Petitioners is one.
So then we'll keep one post vacant. Why should the other post be? Why should the appointment in other posts be held up?
Lordship, that was the direction, Lordship, because as per their contention, Lordship, there was.
Which is the interim order? Interim order dated.
Reservation, Lordship.
Interim order is dated 24/6/22.
In the
I don't think this is page 85.
Is 86 also. In the other I Lordship.
Total, how many how many posts?
Total post was 344. 24 in 100 days, how many 24 page. So authority published a list of 320 now. So this is he is a petitioner doctor, he is a FC candidate doctor. According to him, if 3% post is reserved for PWD category lottery, as 12% were there in the SC category. Going by 3% of 12, it should be 1, not 2.
So at the moment, how many posts are being held up?
In this case, lordship, right now 2 lordships. One has already been vacated.
One post is
So apart from 2, all other post appointments have been made. All right. Now, he has an application for impleadment.
Yes.
We'll allow that today then. Right. Heard Mr. MP Sharma, I had counsel for the applicant. This is IA number 796 of 2000. Item 28. Also heard Mr. KK Mohanto, and his senior counsel assisted by Ms. A. N. Begum, and a counsel for the writ petitioner. Mr. P. Nayak, Learned Standing Counsel, PNRD, Department Assam, and Mr. P. P. Datta, Learned Standing Counsel, APSC. are present on behalf of the official respondents. Full stop. The applicant herein claims to be a selected candidate for appointment to the post of
Junior
junior
engineer,
Jun-
engineer civil lordship,
junior engineer civil in the department of
PNRD.
PNRD. Full stop. According to the applicant, due to the operation of interim order dated 24/6/2022, passed by this court in WPC number 4189/2022, the process of his appointment has been held up. As such, the applicant submits that he is an affected person and therefore be included in the writ petition, giving him an opportunity to present his case. The learned counsel for other parties appearing in this case submit that they would have no objection if the prayer for impleadment is allowed. In view of the above, and considering the statements made in the IA, the applicant Sri Suman Das is hereby impleaded as respondent number seven in the connected writ petition, registered to make necessary endorsement in the cause title. The IA stands disposed of. And in the writ petition, you write, in view of the order of impleadment passed in the connected IA today, registered to list this writ petition along with WPC number 4189/2020 after 2 weeks. In the meantime, the newly impleaded respondent may file affidavit if so advised. And in item 11, you write list along with item 28 after 2 weeks.
There were some directions from this honorable court which have to be complied with by them. Those informations are not coming as yet. They should also come prepared with so that the matter can be taken up and decided.
11 or Devo. In the meantime, the learned departmental counsel to
In 24/6 itself, last part Lordship will find, there was a direction to give all this, and there also it was repeated there subsequently. All these
learned departmental counsel also to examine as to whether the direction issued by the order dated 24/6/2022
and
has been complied with and place the relevant instructions before the court on the return on the next
Yes.
6 days. You're right.
all right.
Right, Lord.
Item 12.
Yes.
Yes,
Last
Yes,
time.
Your Lord. Yes, Your Lordship, this is a matter pertaining to the removal of the RPF constables without giving them a reasonable opportunity of being heard as completed by Article 311. The authorities have directly invoked the Rule 161, Sub-Rule 2, and has removed them from the
so
service.
you have seen there is a judgment. of
Yes,
this?
yes.
Is it covered under the judgment?
Yes, it is covered under
No,
the
that's
judgment. Only the thing is, in that judgment, there were the disciplinary authorities was there. In my case, there was no any disciplinary authority. Just on the basis of preliminary inquiry, they have been removed.
I have submitted a judgment of this honorable court lordship.
Hmm.
The facts are slightly different.
All right,
from-
so we'll have it after the matters fixed at 2, because I am rising at 12:50 today, 12:55 for some meeting. I'll again sit at 2. You are getting this chance because other matters are fixed at 2. You
Yes.
come in the queue.
Yes,
If it has to be finally heard, we'll do it. But after the other matters which have been fixed,
sure.
there are matters fixed at 2. You can do it today or you want another date, it's up to you.
Today only.
All right, then after those cases are heard. Yes. All at 2 after those cases.
Item 13.
12:55 12:50.
One of the, in this matter, I was directed to obtain instruction, one of why departmental proceeding is delayed. I have received an instruction today. Tomorrow is fixed for my lot, recording statements of the Ritudas Bora IS Secretary of Corporation and Ambulathan MP IS Dhubri tomorrow. And Lordship can dispose of otherwise my lord to complete within 6 months.
6 months, within 60 days.
Tomorrow,
No, within 60 days.
tomorrow for statement, my lord, they are not cooperating.
I am not very, sure that they will
No, tomorrow, the day.
Let the repetition, keep pending, Let us see tomorrow what happens.
All right, heard Mr. R. Chakraborty, learned counsel for the petitioner, also heard Mr. T.C. Chutia, learned additional senior government advocate Assam, who has obtained instructions based on the order dated 13/3/2023 passed by this court and submits that the matter is fixed before the inquiry officer tomorrow for recording the statements of the departmental witnesses. Full stop. According to Mr. Chutia, the inquiry proceeding will now be expedited and will be concluded as expeditiously as possible. Full stop. Mr. Chakraborty has, however, prayed for keeping this writ petition pending, seeking an update on the progress made in the inquiry proceeding after 6 weeks. In view of the above, let this writ petition be listed again on 22nd of May 2023. Full stop. The learned government advocate to call for an updated report from the authorities and place the same before the court on the next date fixed, indicating the progress made in the inquiry in the meantime. List accordingly. Yes.
Item 14.
Lord, the matter, my lord, to withdraw the retention of the accommodation, my lord. As per the notification, that is my lord, page 104, my lord. My lord, the 31st is the last date, my lord.
May I please
My
lordship?
lord, the last, my lord, last notification, as per the last notification, my lord, that is 8/4/2021. It was my lord, it is my lord, up to 36/2024, my lord. So,
So they filed affidavit.
We
yes,
have
my
filed
lord, we have
affidavit,
also
lordship.
filed a reason, my lord.
Kind-
Let us
and
along that, my lord.
kindly fix the matter 29 for final disposal, final hearing and disposal, lordship. R.K. Dev Chaudhary will appear in this matter. And as today, he has some series matter in court number 1. Some matter has,
lord,
he has been
Please
lexing.
submit my,
Court
my
number
lord, this notification, my lord, affect my lord, the two officers like the petitioners, my lord, as well as my lord, AIS officers. The AIS officers, my lord, all India service officers, my lord, approach before the honorable, my lord, Central Administrative Tribunal. My lord. The Central Administrative Tribunal, my lord, state this notification, my lord, up to 25/6 or 25/4/2023. My lord, status quo as on date, my lord, only 9 days have been left.
Where is the stay order?
Yes, my lord, I have a, my lord, yesterday I came to know, my lord.
Why don't you also approach the
My
tribunal?
lord, we are the, my lord, the paramilitary forces, my lord.
Yeah.
These are, my lord, we approach, my lord, including the honorable court, my lord.
Why you can't go to the tribunal?
Yes, my lord.
You
There
go
is
to the tribunal. We'll close it today, granting your protection. You go to the tribunal. Tribunal is looking after all these things. Why should the High Court go into this?
There is a, my lord, some bar, my lord.
Huh?
I have a, my lord, some one judgment, my lord, some, there is a, my lord, some restriction. My lord.
May I please, lordship? Kindly come to the page number 162 of my office memorandum. 6 October dated 6 October 2022. Here it is, this OM will be applicable and come into force after 31/3/2023. Number 4, paragraph number 2. And after that, notice have been served to the petitioners. And therefore kindly fix the matter on 29th of this month. Let's say.
We will, but 29th we are going to stay because 29th we cannot
Yes,
hear
lordship,
the matter.
yes, sir.
So there will be a stay on 29th.
Yes, sir.
Yes, heard Mr. Ellen Dingle and you obtain instruction why you can't go to the tribunal. Other matters are there.
My lord, there is a, my lord, one, I have a one judgment, my lord, in regards, my lord.
No. That order will pass, but will give you some protection. You come prepared on that. Heard Mr. Ellen Dingle and counsel for the petitioner. Also heard Ms. S. Burwal and CGC appearing for the respondents to submit that affidavit in opposition on behalf of the
Both respondents.
respondents.
Both respondents.
On behalf of both the respondents had been filed The petitioners have also filed their rejoinder affidavit. First of expressing urgency in the matter, Mr. Dihingia has pressed for consideration of the prayer for interim relief made by the petitioners. Full stop. Ms. Borua, however, submits that a learned DSGI appearing in this case is busy on another court, and therefore the matter be posted again on 29th of March 2023 as a fixed item. In view of the prayer made by the learned CGC, this writ petition is directed to be listed again on 29th of March 2023. On the next date fixed, the prayer for interim relief will be considered. If there is a stay, you will get a stay, but you have to go to the same tribunal. There can't be a one in the High Court of Guwahati, one in Delhi, one in, that's not possible. So come prepared with whatever answer you have on the next day. But granting some interim protection may not be a difficulty. That we are open to considering. Yes. One more item.
Item 15.
May please, your lordship. Lordship, as per office note dated 15/3/23, my lord. Neither AD cards nor unserved notices has been received back for respondent number 1 and 4, my lord. And in respect of respondent number 2, it has been received as unserved and refused. And in respect of respondent number 3, it has been received back as unserved, as no such person, my lord. I may be allowed to take steps, my lord, upon respondent number 2 and 3, my lord, and others may be awaited, my lord.
Heard Ms. B. Boral and counsel for the petitioner, Peru's office note dated 15/3/2023. Await service report on respondent numbers 1 and 2. Respondent number 1 and 4. Since the respondent number 2 has refused the notice sent by this court, service of notice is deemed to be served on the said respondent. Registry to verify as to whether any counsel has appeared on behalf of respondent number 2 and reflect the name of the counsel in the cause list. On the request of Ms. Bora, leave is granted to the petitioner to take fresh steps for service of notice upon respondent number 3 by ascertaining his correct postal address. Let steps within a week from today.
Lordship, similar prayer, my lord, in items number 16 and 17, my lord.
Same respondents.
Respondent number 1, 3, and 4 are awaited, my lord.
Mm.
And in respect of 2, similar as refused. It has come back as
Item?
refused. 16 and 17, my lord. Similar order for 16 and 17.
Yes.
Lordship.
Check the office note and respond number 2 is. One
Deeply
more.
Item 18.
My lord, as per our instruction, my lord, he is the person, my lord. Only, my lord, some designation has been changed. He's coming, my lord.
No, you have to correct your error of party.
Landed friend.
Anyway, if they can make the correction, because I have informed the department, lordship, the department is asking for 4 weeks time to dispose or to pass a speaking order regarding the appeal which the petitioner has filed, my lords. That is the main grievance which he is facing.
Then we'll say that you have appeared for the respondent.
Yes, lordship, I have appeared.
Heard Mr. Jiuddin, learned counsel for the petitioner, Mr. H. Chalia, learned counsel has appeared on behalf of the sole respondent and raised for 4 weeks time to obtain instruction and appraise this court as to the steps taken for compliance of the court's order.
Lordship.
Prayer allowed. List this case again by showing the name of Mr. Chalia in the cause list.
I am for the respondent number 3, my lord. My lord, right, my lord, but my lord is a stage, my lord, since 2017, my lord. Contact labor, my lord. And if you lordship can give a date, my lord.
If 26, my lord, I have.
Yes.
After you.
26.
Publish.
Lordship, in this case, I have already submitted it. Week ago is on legs in a part-head matter, Lordship. And in this case, Mr. AG will appear. Today it is not possible for him.
Restorative court के दिया उसने
हाँ जी
अच्छा
आजके दे दिया ना
But there is a list of date possibly on the record, or I'm submitting one. It could be there. I am appearing in 6 and 7, no?
6 and 7.
6 and 7, my lord. 6 is an Ayurvedic Association, Doctors Association. The secretary and the president has come before your lord. They want parity with regard to the enhancement of the age of superannuation that was given to the allopathic doctors and the dental surgeons. They claimed it before the government did not do anything, therefore this petition. Before I take your lordship to the other things, my lord, list of dates. This was in the scheme of my lord, central government scheme. If your lordship takes up my lord, 7707. At page 29, your lordship is to see. That was a notification by the central government enhancing the age of superannuation of teaching, non-teaching and public health subcadres of Central Health Service to be 65 years from 60 years. Page 29. And page 29, in terms of that, my lord, 29 of the page 30, Central Civil Services officers, that is, allopathic doctors, were given the question of enhancement of age up to 65 years. In terms of that, there was a budget speech and then the health minister said that in terms of the central decision, it will be done in the state health service also. Page 36 is the notification so far as we are concerned. Page 36. In pursuance to the cabinet decision dated so and so, government is pleased to raise the age of retirement of allopathic doctors, all cadres and dental surgeons working under the Health and Family Welfare Department from 60 years to 65 years. Dental surgeons and the allopathic doctors were given, but the Ayurvedic doctors were missed out. Then the notification is annexation 9, page 38. Well, yes, under the permanent payroll, they serve the same thing. I have given paragraph 20 of my writ petition, your lordship. Paragraph 20 of my writ petition, I have delineated the course of study and the service status. Basically, it's also the same. They are also appointed as medical officers, health 1, medical officers 2, and the service status, your lordship, please see at page paragraph 20, clause 3, the same thing. OPD, they have those, the pay scale is also the same. So far as the dental surgeons are concerned, allopathic doctors are concerned, and Ayurvedic doctors are concerned. Pay scale same, nature of duty same. So far as the dental surgeon is concerned, they have only OPD duty, but nothing of that sort. Rural incentive is a 4,000, and the same is provided to the Ayurvedic doctors also. And there is no counter to the paragraph 23, paragraph 20. Though they filed a counter affidavit, but no controversy with regard to that one. Well, but then there's no rule as such. So far as the Ayurvedic doctors or allopathic doctors are concerned. But there is an order. What's that?
Yes.
18. Well, there is a central health services were concerned. The allopathic doctors were not given. The Ayurvedic doctors were not given the question of enhancement. So far central health services were concerned. They approached the CAT at that point of time. The Delhi bench of the CAT, Central Administrative Tribunal, they allowed their petition. Then the department approached the Supreme Court. Supreme Court ultimately has given it to the petitioners. I am placing that judgment before your lordship. That is there. But subsequently, my lord, during the pendency of the Supreme Court case, the central government extended the benefit to the Ayurvedic doctors also, but from a different date, subsequent date. That was also set aside. Paragraph 22 and 23 of this judgment, my lord. Paragraph 22 at page 17. The common contention of the appearance before us is that the classification of the Ayush doctors and doctors under the CHS in different categories is reasonable and permissible of law. This, however, does not appeal to us, and when inclined to agree with the findings of the tribunal and the Delhi High Court that the classification is discriminatory and unreasonable, since doctors under the both segments are performing the same function of treating and healing their patients. The only difference is that the Ayush doctors are using the indigenous systems of medicines like Ayurveda, Unani, etc., and CHS doctors are using allopathy for tending to their patients. In our understanding, the mode of treatment by itself, under the prevalent scheme of things, does not qualify as an intelligible difference here. Therefore, such unreasonable classification and discrimination based on it would surely be inconsistent with Article 14 of the Constitution of India. The order of Ayush Ministry, dated so and so, extending the age of superannuation to 65 years, although endorses such a view. This extension is in tune with the notification of the Ministry of Health and Family Welfare 31/5/2016. The doctors, both under Ayush and CHS, render service to the patient, and on this core aspect, there is nothing to distinguish them. Therefore, no rational justification is seen for having dates for bestowing the benefit of extended age of superannuation to these two categories of doctors. Hence, the order of Ayush Ministry, so and so, must be retrospectively applied. Well, during the pendency of that, as I saying before, during the pendency of the case before the Supreme Court, the Ayush Ministry extended the benefit to the Ayurvedic doctors, but on a subsequent day. That was held to be not correct, and they will be given the same benefit as given to the allopathic doctors with effect for retrospective. 31/5/16. That was the date of the notification. In terms of that one, my lord, Rajasthan High Court has recently passed a judgment extending the benefit to the Ayush doctors.
This judgment is not reported.
Not yet.
Check if this is reported.
Not yet.
Hmm.
Following this judgment, my lord, there is a Rajasthan High Court decision extending the benefit to the Rajasthan doctors.
Hmm. So why so many petitions? All these are by individuals or association?
Individuals.
Your petition is by association.
By association and one by individual. 6 and 7, no? 6 and 7.
6 is by association and 7 is by individual.
They have retired.
And in the meantime, he has retired.
So then it is over for him.
No, my lord, I will submit, my lord, in that regard, that the retirement would not be against them because the question of if they are entitled to constitution, the salary they may not get, but so far as the pensionary benefits are concerned, they are entitled to. That your lordship is pleased to consider. That the Rajasthan High Court has considered that one.
Where is the Rajasthan High Court?
I have given word. It has quoted the judgment of the Supreme Court and then said, but last page 4, we place on record the fact regarding petitioners having already retired after attaining the age of 60 years after the issuance of notification enhancing the age of retirement from 60 to 62. In that case, it was 60 to 62 years in respect to allopathy doctor. As the petitioners have retired after so and so, the petitioners are also entitled to the same relief which has been granted to us by the aforesaid case. However, the petitioner shall be deemed to have continued in service till attaining the age of 62 years. This will require the respondent authority to pass necessary orders treating the petitioners to be in service till attaining the age of 62 years with all consequential benefits of continuity in service. We also make it clear that all other consequential action will also be required to be taken, which includes appropriate orders with regard to the pensionary benefits which the petitioners have already availed. Member, আমাদের association কজন member আছে?
Next are 4. Next 4 after each petition. Ahora, interim order in the
Interim order?
interim process, this to success. They will get their
Annexure 4.
order.
Annexure 4 to কত? Page. Annexure 4 maybe.
It does.
The revision be order to
Okay. I think it's-
Oh.
So this was still 62 years, just.
That was 62 years, 60 from 62, 60 from 60 to 62. In our case, it is from 62 to 65.
62 পর্যন্ত administrative post থাকবো 65 non administrative
আমাদের ইয়ে করছে কম
up to 62 administrative post holder.
right now. Page 36, my lord. 60 to 65 years.
Yes.
But during the filing of the petition, at the initial stage, there was an interim order because we had expressed, my lord, that certain persons were going to retire at annexure 4 at page, page 28. These are the persons who are going to retire on attaining the age of superannuation during the pendency of the petition. There was an interim order, but when the state moved in for a writ appeal, and in the writ appeal, the order was passed that in the event they succeed in the writ petition is allowed, that would be annulled to their benefits. What would be copy of the I'm having this copy. Or the copies are possibly in the file. That is the division bench order. No, no, no.
Hmm. Yes.
Lordship, in this case, actually, I cannot say anything, Lordship, because argument will be over by the Advocate General, Lordship. So, Lordship, may fix a date, Lordship.
No, we'll finish up these matters today. It can't be. This was fixed after taking your consent, and in the morning we fixed it at 2. We did not say anything after the matter was heard.
That time also, I placed with your Lordship that we go.
We'll pass an order day after tomorrow. Day after tomorrow, the judgment
No,
will be
no,
delivered.
my lord, no, my lord.
Huh?
Another date, Lordship.
Not possible. Then you have to go for an appeal if it goes against you. You want it day after tomorrow? I'll dictate the judgment now.
No, Lordship. Judgment will be delivered before the Advocate General.
No, you can't dictate the court. This is my discretion.
Lordship.
When the matter is going on, I'm saying if you want, we can post it on Thursday at the most, not beyond that.
Thursday.
Thursday. All right, Thursday.
On Thursday, Lordship will hear me also, Lordship.
Today you argue. What is the problem?
Lordship, I can face the facts, Lordship.
Moreover,
Lordship, we have submitted a written synopsis also, Lordship. That also
you are in which case, which matter?
Lordship, item number 9, Lordship. But however, Lordship, the written synopsis in the leading case, your Lordship, that is the association case.
Association.
WPC.
There are bunch of papers I find, but we had submitted a written argument also. But if it is required, my lord, your lordship, keep it aside, and then I will submit a fresh one.
Give it back. Ms. Bora, you see, if you want an opportunity to place your case, the court is open to it. But we will go ahead with our work. Little accommodation is fine. Thursday, this matter will not be adjourned.
Lordship.
You come prepared, whatever is your submission, you make it. Then we'll, after considering both sides' argument, because we have to dispose of cases.
Lordship.
We can't keep these matters pending. 2018 matters, how long do you expect the court to be? And this issue is about retirement age. They are seeking parity. You have to tell us. Your stand is already out in para 5 of the affidavit. You can't say anything more than that. So, fixed partnered matters, yes.
Lordship, Lordship, you take item number 9, your Lordship, WPC 4008. Lordship, I was appointed in the year 1989, Lordship, on the recommendation of the APSC, Lordship.
No, your case is different.
I'm an individual, Lordship, same case, Lordship, similar.
Then what do you want to argue?
Lordship, I just want to add few submission.
We'll add on law points, that's all.
Yes, Lordship.
Yes.
Lordship, I submitted in the written argument, Lordship, but however, I'm submitting one more, Lordship.
Hmm.
A very short one, Lordship. Lordship, you come to page number 3, Your Lordship. The other 2 pages are the facts, Lordship.
No, facts we will not write in any case.
Yes, Lordship, that's what
The
I'm.
issue is whether Ayurvedic doctors also should be given the parity of retirement age of 65 or not.
Yes, Lordship,
These matters, there are notifications, there are judgments of Supreme Court, there are judgments of.
exactly, Lordship.
What is that additional point you want to make? You
Lordship,
tell
I
me.
just want to say, Lordship,
Hmm.
that during the COVID also, Lordship, they are obviously disputing that the allopathic doctors, they are pressure, they have lots of pressure, they have lots of work. That's why there is a scarcity of the allopathic doctors. That's why the age has been enhanced, Lordship. But in addition to that also, means like as a Ayurvedic doctor also, Lordship, I have served in the COVID period also, along with the allopathic doctors.
That's fine, nobody is denying that.
Yes, Lordship. And moreover, Lordship, regarding the Lordship.
They are saying that there are a number of unemployed Ayurvedic doctors. On the other hand, in the allopathic and dentistry, the number of doctors are depleting. That
Yes,
is why these are 2 different categories. Therefore, the government has enhanced the age of retirement for the allopathic and dentist, whereas kept it at the same level for Ayurvedic doctors. What do you have to say on that?
Lordship,
Address the
regarding the
question.
entry, Lordship, just a small point, regarding entry, whatever there is entry 3, Lordship, there is a union list, the state is bound to follow that 3, Lordship, because in central government, Lordship, the age has been enhanced to 65 years, the state is also bound by that, Lordship. Only this.
All right, you take down her, Mr. B.C. Daslan, a senior counsel assisted by Mr.
S.H. Roma.
Huh?
S.H.
S.H. Roman, Lord Counsel appearing for the writ petitioners in item 6 and 7. Also heard Mr. D.J. Das, Learned Counsel for the petitioner in item 9. Arguments on behalf of the writ petitioners have been addressed. First of, however, Ms. D. Bora, Learned Standing Counsel, Health Department Assam, submits that these matters be posted again on Thursday, that is, give the date, so as to enable the State Council to address arguments. Full stop. These are old matters pertaining to the year 2018, and it prima facie appears that the issue is covered under the decision of the Supreme Court rendered in the case of Eto Nam to whom I full stop. Therefore, when the matter was fixed today at 2 p.m. with the consent of the Learned State Council, it is surprising that a further prayer for adjournment has been made today. However, in order to avoid any prejudice being caused to either side, and also to give an opportunity to the Learned Departmental Council to present its argument, his argument, these matters are directed to be listed again on 23/3/2023 as fixed parted matters.
Obliged, Lordship.
Item 12,
Much obliged, Lordship.
Any appeal has been preferred against this judgment? Anybody is aware?
No, Your Lordship.
May I please proceed? Facts are slightly different.
Let him first argue.
Yes, sir.
Your Lordship, I will just start up with a quick touch of that fact, of this entire fact. Then I will directly come to the legal points. So, Your Lordship, it was 23/3/2020 evening. A few persons with a motorcycle and other on the foot carrying a black bag, which appeared with a heavy weight coming from the sick line of the railway, which raised some doubt, including their steps and activities that were marked and observed as doubtful. The petitioner presumed that those persons were carrying some railway materials as there are also law for unlawful possession of railway properties. So on that aspect, these petitioners presume that those persons were carrying some railway materials, and that's why they were wanting to cross line railway line immediately. And thereafter, the petitioner, with the help of one person who was also in the shift duty at Sikh line, caught the one, and whereby other accompanying the original accused flew away. After that, during the interrogation, the local police arrived at the spot and suspected the petitioner involved in the matter of some contraband goods. The suspected contrabands were recovered from the possession of the original accused, and thereafter the local police wrongly made the petitioner a scapegoat into this case, and thereby arresting the petitioner without the permission of the controlling officer of the petitioner. And after this said alleged incidents dated 23/3/2020, the petitioner was removed directly from the service. However, an appeal was made, and a revision application for the decision of removal was also been made to the higher authorities. That was simultaneously been rejected by violating Article 311, which resulting them to giving a reasonable opportunity of being heard. That was directly been made. However, the removal order speaks of Rule 161 of RPF rules, which says that not mandatory to hold any inquiry, but substantially by writing a reason must be recorded in writings for removal. But in the affidavit filed by the
Where is the order of removal?
order of removal is at page 35. Page 36, last line. Therefore, by exercising the power under Rule 161 sub-rule 2 of the RPF rules, 1987, I hereby impose the penalty of removal from service with immediate effect to both Constable Arun Sharma and Constable Ayush Tomar. The second one is the petitioner here in this case. Your lordship will find on the last occasion.
Just a minute. Let me go through the order. What happened in the criminal proceeding?
Present status is the matter is on evidence and all the witness has been examined and the witness has turned hostile.
Let me see, where is the rule 161(2) of this RPF rules? Yes.
Now, your lordship, when this entire proceedings was been going on, in that, in the meanwhile, there was one case reflected in the Honorable Supreme Court, that is the Ram Bahadur Yadav's matter. I think a copy I have provided your lordship. The last petition. Ram Bahadur Yadav, Union of India and other versus Ram Bahadur Yadav.
Yes.
In that Ram Bahadur Yadav judgment, in paragraph number 9, the Supreme Court specifically says that from the reading of the above said rules, it is clear that to pass an order as disciplinary measures by adopting a special procedure in certain cases, Rule 161 itself mandates recording of reasons. The normal rule for conducting an inquiry is governed by Rule 132, 148, and 153 of the RPF rules. If the authorities invoke special procedures, unless they record reasons as contemplated in the rule itself, no order could have been passed by invoking Rule 161. At no point of time, the appellants have produced file to show that any reasons are recorded in such file also. It is settled legal position that when rules contemplate method and manner to adopt a special procedure, it is mandatory on the part of the authorities to exercise such power by adhering to the rule strictly. Dismissal of a regular force, member of force is a drastic measure. Rule 161, which prescribes dispensing with an inquiry and to pass order against a member force, cannot be invoked in a routine and mechanical manner. So, your lordship, after this judgment, there was a notification which was being circulated by the railway board. And this typed copy discloses that a direction was being made to all the principal chief security commissioner of all zonal railways, stating that on pursuit of the court order, this was another court matter which was been running on the Gujarat High Court. Based on that, this order came into place. This railway board circular. On pursuit of the court order cited, it has been advised by the competent authority to desist from initiating action under Rule 161 of the RPF rules 1987, except when action under Rule 153 is not feasible. Now, for the time being, if your lordship may just see 153, Rule 153 of the RPF rules. Now, 153 says, procedure for imposing major punishment, and 153(1) says, without prejudice to the provision to the Public Service Inquiries Act 1850, no order of dismissal, removal, compulsory retirement, or reduction in rank shall be passed on any enrolled member of the force, save as mentioned in Rule 161, without holding an inquiry, as far as may be in the manner provided hereinafter, in which he has been informed in writing of the ground on which it is proposed to take action and has been afforded a reasonable opportunity of defending himself. Your lordship, no any information in writing was been given to us, neither an opportunity was been given to us for defending ourselves, and straight away, and through this order, at page 35, we have been removed directly, straight away removed from the service.
Yes.
Now, your lordship may also see the affidavit been filed by them. Page number 79 of the affidavit.
Page number?
Page number 79
Yes.
of this affidavit. It is an fact-finding inquiry report. I will not just go into the details, just a first line of the third paragraph. If your lordship may find, on receipt of the report, DSC means Divisional Security Commissioner, TSK means Tinsukia, asked me to conduct a preliminary inquiry. Now your lordship may just record preliminary inquiry. So preliminary inquiry is not a final inquiry. So on the basis of preliminary inquiry, without giving us a reasonable opportunity of being heard, and orders by the authorities just pass an order removing us from the service without giving a reasonable opportunity of being heard. And the facts mentioned in this report is exact the same replica which reflect in the FIR as well as in the charge sheet. So this is, your lordship, this is a clear violation of Article 311. And therefore this order is required to be set aside. Your
Your client is in jail now.
No.
He's out on bail.
He is out on bail, but he is without service. Also, your lordship, on the last occasion, your lordship has asked me to find out some judgment on the CISF. On this, I have found out this CISF judgment, which is writ petition 8078. In fact, I have shared a soft copy with the other side as well. Here also, some of the facts are some relevancies there, where the petitioner was being restated, and thereafter a writ appeal was also been filed before this court also. Before this court, before the court of Honorable Acting, the then Acting Chief Justice, and then the writ appeal was being dismissed. Also, there is one judgment which is reported in GLT 2019 for GLT 435. It's a Dipali Fukan versus Dibrugarh University. Dipali Fukan.
Yes.
I will just straight away take your lordship to paragraph number 17. Paragraph number 17, last paragraph.
Yes.
Where it has been recorded. Further, the Honorable Supreme Court in Motiram Decca and others versus General Manager, Northeast Frontier Railway and others, reported in 1964 SC 600. In paragraph 86 has held as under. It has to be noticed that both Article 309 and 310 are subjected to Article 311. In other words, if any rule is made under Article 309 as regarded the condition of service of a government servant in the matter of his dismissal or removal or reduction in rank, it has to comply with the requirement of Article 311. So here in our case, the requirement which narrates the mandate of Article 311 has not at all been complied with.
The Constitution. All right, who's appearing for the respondents? What you have got to say?
In Ram Bahadur Yadav case, and there are the regions were not recorded in that case. But here in this present case, regions are recorded in the and the impugned order dated 24 March 2020. The regions were properly recorded also. And in the another writ petition of order of this honorable court, writ petition number 2277, I have submitted judgment of this honorable court. Here also the facts are slightly different also. And in this case, the incident took place in the CRPF battalion, but the present case, incident took place from the out of the duty area. The petitioner was not present in that time on duty, and he was caught red-handed with some contraband goods, and on that case, FIR was not lost. But in present case, FIR was lost and charges were filed. And on the basis of preliminary inquiry, the report has been submitted by the inquiry officer, and inquiry officer was appointed properly, and he was make an inquiry, and on the three witnesses were examined. And after that, on the basis of that inquiry report, the impugned order has passed, and the regions were recorded in the impugned order. That's it.
Yes.
Yes, and that's why I can make a submission that under 161 sub-rule 2, this order has passed and.
Do you want some help from your senior who is behind you? Mr. Dev Chaudhary? Are you also appearing in this case?
Not in this.
Your lordship, in that context. In that context made by the submission from the other side, I will just rely
No,
upon.
she has not yet finished. Let her finish.
Acha, finish. Sure, sure.
That's it, lordship.
Oh, that's it.
And I have also submitted one judgment of Calcutta High Court, lordship. It is an appeal, writ appeal, and last paragraph kindly have a look.
Yes.
May I please? May I read?
Yes. You want to refer to the last paragraph?
Yes, lordship.
Yes.
The respondent writ petitioner has exhausted the provisions of contained under the RPF rule, and the learned single just ignored the subsequent order passed by the DIG and IG of RPF Railway Board and only concentrated on the order dated 21st September 2012 passed by the commanding officer number 88 so and so Chittaranjan, as the order dated 21st September 2012 was passed much before the criminal court arrived at the conclusion, and the writ petition did not challenge the application of the special procedure provided under Rule 161, 2 and 3 of the RPF Rule 1987 before the appellate authority or the authority exercising power of revision. It was not appropriate at such a belated stage to set aside the order passed by the disciplinary authority. We therefore hold that the reasons so assigned by the commanding officer in the order dated 21st September 2012 being passed on scrutiny and assessment of 9 witnesses and 12 documents were sufficient for arriving of a conclusion for invoking the special procedure, and the learned single judge ignored the same and arrived at his findings. The ratio of the Honorable Supreme Court passed in Sasi Bhushan Prasad's case supra is equally applicable to the facts of the present case of the applicants, and as such, the order dated 12/12/2018 passed by the learned single judge in WPC 25140 of 2016 is hereby set aside.
All right. So at the end of the day, what is your answer to his petitioner's submission? What do you want to say? The petitioner is saying at least there should have been adherence to principles of natural justice. That is not barred under Rule
Yes,
161.
in Article 311 also, it is reason must be recorded is there.
No. They proceeded under 161
Yes.
Roman 2, is it not?
Yes,
Roman 2 does not say that even no principles of natural justice is to be followed. Roman 2 only says in special cases, there may not be any need to hold an inquiry.
this,
Holding an inquiry is one thing,
yes,
and when you are condemning a person, giving him an opportunity to hear, this is completely different. Inquiry is for establishing the allegation. But you bring in so much of material, you hold inquiry, you examine witnesses, and you come to a conclusion that, oh, they are guilty. But you don't give them a chance to even speak. Is this the constitutional skill? Order is as hard so and so. All right.